Welcome to Advocating for Dads with Jana Jones.
Welcome to Advocating for Dads, the podcast where we dive into family law issues and provide practical advice to fathers navigating the complexity of custody, divorce, and separation. I'm your host, Zofia Morales, and joining me is Jana K. Jones, a dedicated family law attorney who's been serving fathers in North Carolina since 2009. If you're a father in North Carolina, you don't want to miss the expert advice Jana has to offer on how to create a separation agreement that works for you and your children. Today's episode is When Life Changes, Adjusting Custody and Support Orders the Right Way. Welcome, Jana. We're so happy to have you back with us today.
Hi, Sophia. It's good to see you.
So, let's dig into this a little bit because, we make these agreements based on what's going on in the moment. And then, of course, life happens. So what should you consider when you're going back to court to modify a custody or a support order?
So the court requires a substantial change in circumstances since the entry of the previous order to give the court the right to change your order. Okay. So if you do not have a substantial change, then you do not give the court enough of a basis to make a modification. Substantial changes with custody orders are typically going to be a situation where something has happened with the parents or the child. So the parent might be moving to another state. Maybe they're getting remarried and going to be relocating. Maybe something has happened with the children. There might be behavioral issues or grades are going down. The children might have gotten older. When you first get an order, it might be a young child that was in daycare. Now we have a school-age child and their needs have changed. Maybe they're in extracurriculars and one parent isn't really following through. And so now we've got to change that order around so that the child's best interests are maintained. So those are typical reasons why the substantial change in circumstances requirement is being met and would allow for modification of the custody order.
Can you give us some examples of things that are not substantial changes? You mentioned a few that are where there's a move or the child has aged into a different phase in their life. What are some things that a layman might think is substantial that the court would not agree with?
Well, simply that the child has gotten older is not going to be enough. The court expects the child to get older. So
right.
That in and of itself is not going to be a substantial change. And a lot of times parents feel like, the child was this age and now they're 5 years older. So automatically we need to change it, right? And it's not that simple. We still have to prove a substantial change in circumstances. And that's probably the biggest misconception on how that process works.
Interesting. So how does relocation, job loss, and the change in the child's needs affect the legal orders generally?
So again, the court has to see that there's a substantial change. And once they determine that there is enough of a change, then they have to still make a best interest determination. Everything always goes back to the court's polar star of determining what's in the best interest of the child or children. So once they see that, yes, there is a change that's going to precipitate the need for us to change this order, then they still have to evaluate what change is going to be in the child's best interest. And oftentimes that is going to mean a change in the custody, but sometimes it won't. So you might have a situation where the substantial change is one of the parents, maybe the primary custodial parent, is going to be moving out of state, right? But they have primary custody. Well, maybe if they're only moving a couple of hours away, while that might be a substantial change, the custody doesn't actually change because the best interest of the child is still served by that parent having primary custody.
Is there kind of a tipping point where you see like the distance in a relocation becomes more of a factor?
Usually the tipping point is if you have a joint custody schedule, for instance, one of the parents is moving to a place where they can't get the child to school on time anymore. Right. So if you've got a situation where somebody's moving just down the road to Rock Hill or Fort Mill, well, that's a very different state than North Carolina and Mecklenburg County and Charlotte. It's basically a suburb of Charlotte. And so that parent could still potentially fight traffic on 77 and get their child to school on time if they wanted to.
Right.
Whereas if you have someone who moves to Georgia or moves to Virginia, that's just not going to be tenable anymore.
Interesting. So what are some examples of a change in the child's need that would require a change in the legal?
Sure. So something like behavioral issues for the child. Maybe the child was doing well and suddenly there was an issue with their behavior and we're trying to determine why that's happening. Maybe their grades are not good. Maybe they're not getting to school on time. Maybe they're missing a lot of school. Those can be major changes. Additionally, the attitude of the child can come into play. When the court is dealing with older children, typically maybe 12, 13 or older, some judges will take into consideration the desires of the child. Ideally, that is figured out in chambers where there are not parties present and the child doesn't feel any type of stress and is able to speak freely with the judge. But oftentimes, and unfortunately, it may happen that you have to put the child on the stand. But either way, the court will take into consideration what the child is saying that they want, assuming that they are old enough to make a decision like that, and the court feels that they have the maturity to express how they feel to the court.
Okay. Yeah, that makes sense. Is there kind of a rule of thumb for when a child is entering that phase, or does it kind of depend on the decision and the judge involved?
It really does depend on the judge, but I would say on average, you're probably talking about a child that's at least 12 or 13 years old.
And so, what is the actual process of requesting a modification? Say you're pretty confident that this is something that might be allowed. How do you go about making that request, and how long does it take usually to get official blessing on whatever the agreement worked out to be?
Sure. So, unlike when you're getting an initial child custody determination where you have to file a complaint and you have to serve the other party, with a modification, you're just serving via regular first class mail. So, the service piece is a lot easier. You're sending it to their address, and that's it, just first class mail. As far as the procedure, it's going to be very similar to what it was on the initial determination of custody. The parties still have to go through court order mediation to see if they can resolve the matter in mediation. But if they're unable to resolve it there, then it will be scheduled for the judge to make a determination.
And so if we're kind of rule of thumbing the time frame on that, are we talking a few weeks, a couple of months? What's the situation around that?
So that's probably going to be in the months purview.
Okay.
Possibly years. It really just depends on the judge's docket. I would say that it would take anywhere from 3 to maybe 6 months to get into mediation, depending on how backlogged the custody mediation office is. And then from there, you're probably, if mediation's unsuccessful and you're going to be going to trial, looking at another 3 to 6 months for an actual court date. So generally speaking, if you're going to have to go all the way to trial, it's going to be at least 6 months, possibly a year, maybe more.
Yeah, this could get really, what do I want to say, tangled up and involved if there's like a relocation because of employment involved. I can see where this could become a mess in a hurry.
Absolutely. Yeah. So ideally, if that's the reason why you're wanting to modify your order, speak to the other parent. Hopefully you guys can figure out a compromise, at least in the interim. But otherwise, the court does still expect you to follow the current custody order that is in place. And so that means if you've got joint custody and you're going to be moving out of state and that is not going to allow for you to get the child to school on time, then technically you probably should be leaving that child with the other parent for that child to be able to maintain their standard of living where they're at currently. But obviously that doesn't always happen. Sometimes that parent will take the child with them. There is a basis to potentially get into court a little bit sooner than going through the process of waiting for mediation. And that's called a motion for a temporary parenting arrangement. And what that's doing is saying, hey, court, we know there's this whole process. We know we got to go to mediation before we can get a permanent order. But can we kind of skip the line and get a little bit of time and get a temporary order in place? Because without that, we're just kind of in this chaotic situation. And so that motion can be a part of your motion to modify, or it can come after you file your motion to modify. And the court has the discretion in whether or not they're going to grant that hearing. If they do grant that hearing, that is going to be a very quick hearing, usually 30 minutes to an hour. And it's basically what I say, putting a Band-Aid over a bullet wound. Obviously, there's a big issue going on, but we're trying to get something in place for the interim because we know that we ultimately want to change the order permanently. But right now, there are circumstances at play that are going to require that we get the court's attention a little bit sooner.
Right. I know you mentioned trying to make agreement with the co-parent that's involved. How does that work? If you are able to come to a verbal agreement that people are happy with, what steps do you need to do to kind of formalize that or be able to start going down that road without getting sideways with the orders?
So I would recommend getting it in writing, not just verbal. So even a text message or an email, just something. But you will not be able to change a court's order with a verbal agreement or a written agreement. Only a judge can change the order. So you're still going to have to go through the process of filing a motion to modify, but you can reduce your agreement to something called a consent order. And what that is an order that's drafted by usually an attorney who is going to break down what the new agreement is. And then all of the parties are going to sign along with the attorneys. And then that order gets submitted to the judge for the judge to sign. And assuming that it's a consent order with all parties signed, generally speaking, the judge is just going to sign it because they know it's an agreement.
Okay, that sounds tidy if you can make that happen.
Absolutely. But it's going to require that you do have an agreement.
Absolutely. So say you have something coming down the pike that looks like it's a substantial change in circumstances. Are there any risks involved in reopening a settled order? And can you have unexpected nasty surprises?
Yeah, I mean, you can file for a modification because you want the change that you want and it goes the other way, right? There's always litigation is inherently risky. And so if you don't know that you've got an agreement with the other side about how you're going to resolve the issue, you don't know what's going to happen. And it's ultimately going to be up to a judge if the two of you cannot agree.
Okay. So there is a bit of a gambling aspect here. Are there ways we can reduce the risk of that? We mentioned talking to the other co-parent.
Exactly.
Is it a little safer if you went through a mediation than like straight to the court, or how does that play in?
Yeah, absolutely. That's a great option for folks who don't feel like they're miles apart, but they're still trying to work through some issues. Mediation can be a really great resource, and it can be done outside of court. So what can happen is the parties can choose to voluntarily mediate, and then someone can go ahead and file for the modification, and then the agreement can be reduced to that consent order. And that way you kind of have a lot more clarity and surety about what's going to happen because you know it's been reduced to a consent order, as opposed to taking that gamble and going to court and seeing what a judge ends up ordering.
And so how do you start to document your case to make sure that the court gets a clear vision of what your side of things is?
So the best thing to do is to keep as much as you can in writing. Text messages, emails are going to be your primary source of exhibits. But I often tell folks that your testimony is your strongest evidence. If a judge does not believe you, if you do not come off as credible, if you don't come off as responsible, if you do not come off as the parent that is trying to co-parent with the other parent, all the evidence in the world isn't going to help you. Right? The judge is trying to determine what is in the child's best interest. And so you want to make sure that you're very clear when you're coming across to the judge about facts and information. Something as simple as, do you work remotely? Like it's pretty obvious question and answer, right?
Yeah.
But I've had folks, be a little bit confused in how they're answering that question. And now that's giving the judge pause, like, well, if you can't just answer a simple question with a straight answer, then how am I going to trust your answers on more complicated questions, about the child? So you want to be very clear and thoughtful when you're answering questions, when you're testifying in court. That is going to be the absolute most important thing that you can do to prepare.
I like that. So what are your final words of wisdom for a father who's facing one of these situations where it's like, yes, we definitely need to work through another agreement because of changed circumstances?
So I would say start with your co-parent. See how far apart you are. See if you guys can reason and work together and figure out a new schedule that's going to, be a compromise you both can live with. Each of you is entitled to move on with your life. You may meet a new partner, you may get a new job, and that may require that you move, and just by default, the custody schedule is going to have to change. So give each other grace with that and try your best to figure out a new compromise, a new normal. If that's not going to work, then you're going to want to seek out legal advice as soon as possible. And I would say even frankly, before you talk to your co-parent, just to get an idea of what your chances are of being successful in court, so that as you're talking to that co-parent, you know whether or not you're, doing a Hail Mary here and hoping for the best, or if you've got some, pretty strong information behind you, knowing that, hey, I'm trying to work with you here, but ultimately, if you're not going to work with me, I think I'm going to be successful in court anyway.
All right. That sounds like most excellent advice. I think the advice I would give them is make sure you call Jana K. Jones.
Absolutely. Give us a call. We're happy to help.
Thank you so much for coming and sharing your wisdom with us today, Jana.
Thank you, Zofia. Look forward to seeing you again soon.
All right. And thank you for joining us on Advocating for Dads with experienced family law attorney Jana K. Jones. To connect with Jana, head over to lawofficeofjkj.com and be sure to like, subscribe, review, and share this information in this video with those you care about.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one.